this opportunity to thank all of our visitors for their works, for their participation in this workshop. I also take this opportunity to thank all the people that is following us online through this, have been following us online through this workshop. And now it's my pleasure to introduce Dr. Tsachi Keren-Paz, who is professor at Kiel University. His research has been about tort law and contracts, and being his main work, the book Torts, Egalitarianism and Distributive Justice. With nothing further to add, let's hear Tsachi.
Thank you very much, Pedro, and thank you, Diego and Jody, for inviting me again to Girona. It's always a pleasure and big pleasure to be here. I feel that my paper is a bit different than the others in the sense that I didn't have like one or two major points, but more of like a collection of points. For this reason, I also prepared a PowerPoint. It would be easier to follow. So my interpretation of Jules' contribution in the book, or the main two things that I think he was trying to do in the part of in the third part of the book, is first the proposition that corrective justice ought not to explain all tort law. Deviations from corrective justice are not mistakes. And the second issue is the scope of corrective justice. What claims for compensation are a matter of corrective justice and what are not. And and I have sets of comments about each of these parts, and I will go in reverse order. An uncharitable reading of my paper would be that the first part asks why Jules hasn't written the book that I've written 15 years after, or why hasn't he read it before he wrote his. And the second part is why did he write about corrective justice what he did. So I would like to start with the scope of corrective justice, and then to move to the role of other consideration, my take on his take on this. So, one point about the scope of corrective justice is that I think his account is too narrow in the sense that he excludes wrongs and wrongfulness and wrongful gains from the ambit of corrective justice. So, his point is that the point of corrective justice is to correct wrongful losses, not wrongs themselves. And I wonder why not both, or why not focusing on the reversal of the transaction, as John mentioned yesterday. I would like to add a few points to this line of critique. The first point is that it seems to me that this account doesn't sufficiently distinguish between torts in which damage is a part of the constitutive elements of liability and torts which are actionable per se. Now, Jules said several times in his book that he's interested in the core of tort law, and the trespass torts seems obviously to be part of that core. And to me, it raises the question, if we don't have damage there, so would Jules say that these torts are not a matter of corrective justice, or would he imagine some kind of reversal The other thing that Jules said in the book is that it's the role of the criminal law to annul the wrong, not of tort law. But this seems to me hard to accept based on two different points. One, it's really hard for me to see how criminal law really annul the wrong. You know, if someone kills someone else and goes to jail, it's not obvious, intuitively obvious to me that the punishment that is imposed really annuls the wrong. And then I think this leaves still the difficulty: what happens with civil wrongs without a criminal counterpart? So do we say that there was no wrong at all because there's no criminal liability? Or do we say that in this case, corrective justice annuls both the wrong and the wrongful losses? Or do we say that in this case, only wrongful losses are annulled, but there was no wrong since there's no criminal liability? So this is one point. Then obviously there is the issue that I think we also mentioned yesterday, that the exclusion of wrongful gains from the ambit of corrective justice seems to be unjustified. I think it's just another mode in which corrective justice operates. Sometimes it annuls losses, sometimes it annuls wrongful gains. My second point is about the account in risk and wrong of wrongdoing, which is roughly covers the tort of negligence. This is the core as I understand it. And I think in this sense, the account in the book is both too narrow and too wide. I think it is too narrow when it classifies liability in cases of problems of proof about causation as justified deviations from corrective justice rather than an expanded form of corrective justice. And in this sense, it seems to me that definitely if you look at the annulment thesis, we would accept cases like Haimovich, the market share liability line of cases, or Summers as corrective justice. I still think that this is the case. I think that the core of corrective justice is that tortfeasors would pay what the damage they cause, no more nor less. That the claimants would receive the damage that they suffer, the wrongful damage, no more nor less, and that this would be based on transactions, on the relationship between them. And the fact that we have some kind of victim swap doesn't take it from the realm of corrective justice. It's an expansion, but it's still a matter of corrective justice. So I didn't see the reason to treat it as a justified deviation. Some would say it's slightly more difficult because there it's clear that one of those found liable didn't cause the physical harm, but I think it could be explained as a matter of corrective justice, either based on the idea of evidentiary damage that the other hunter caused, or some kind of as a second best corrective justice solution, that if we accept that from a corrective my third point about the scope of corrective justice is about the blurred line between the three cases of compensation that exist. One for wrongdoing, roughly negligence, one for wrongs, roughly the strict liability for breach of rights, and liability rules, which are not a matter of corrective justice. Jules give the example that if I go to a restaurant and order, so I haven't committed any wrong, but I still need to pay for what I've ordered. And for Jews, the third category is not a matter of corrective justice. And I have some doubts about the usefulness of this tripartite division. So first, about the borderline between wrongdoing and wrong. The book is silent on what is the difference between legitimate interest and right. So it seems to me to be a bit circular, because I have a right if something is protected by strict liability rule, while if something is protected only by a wrongdoing, by negligence, so I don't have a right, just a legitimate interest, that if it's being interfered with by wrongdoing, so there would be liability. And it's hard for me to see why it is useful to say that I have a right only if it's protected by strict liability. In what sense I don't have a right that Martin wouldn't negligently run over me? I don't see a problem saying that I have a right for that, but I don't have a right that he would compensate me if he drove without negligence, unless we have a rule of strict liability. So, yeah, that's about the first category and the second category. And then I suspect that I'm even more bothered by the line between wrong and prices which are non-corrective justice mode of compensation, which is the third category. And I think that the necessity cases demonstrate the difficulty. So, in the book, Jules suggests that Vincent has the dog owner has a right to exclude, but or part to exclude, but he would be liable to pay for the consequences of excluding the owner of the sheep. So, first of all, conceptually, it seems to me a bit odd to say that I have a right, but I need to compensate if I exercise this right. In what sense it is a right if at the end of the day I need to compensate for it. But also it's based on assumption which I seriously doubt whether it's correct, that there was a right to exclude in this case. And when you read Vincent, you see that they refer to a previous Vermont case of Plouffe, in which the court said that it was not trespass to tie yourself to the dog, and that conversely, if the dog owner in Plouffe it happened that it untied the sheep, it was liable for the damages to the sheep. Now, if you would imagine that something like this is going to happen today, and we phone with a mobile to a judge and ask for an injunction, I think no one would dispute that the judge would issue an injunction against the dog owner to prevent him from the sheep owner tying the sheep, and definitely, which is all what I need to show as a matter of critique, that he wouldn't issue an injunction against the sheep owner trying to tie. So I don't think there's any right to exclude here. So what Vincent could be these were my points about the scope of corrective justice, and now I would like to say a few words about the Jules account of the role of non-corrective justice considerations in tort law. So I think that it's an important contribution of Jules, and in this sense he stands out in comparison to other corrective justice theorists, that he accepts that tort law is not only or not all about a corrective justice, but obviously this raises the question, what is the role of other considerations and how they interact or interplay with the corrective justice. So, from reading the book, I think that Jules suggests that liability which cannot be supported as a matter of corrective justice could be supported by considerations of efficiency or law spreading, but I think he suggests that only by these two considerations. So this implicitly excludes corrective justice theory is like Rob Stevens would say, would insist, you know, that the reason that I need to compensate John if I punch his nose is that it's a violation of John's right, and not because it would prevent me and others to punch other people in the future. But this is an easy case because both of them, both considerations go in the same direction. I think it would be much more interesting to ask whether as a matter of corrective justice I need to compensate John if I could really prove that if I would have to pay compensation to John, the rest of you would get patches on the noses, which is counterintuitive. But if this is the case, so we could say that as a matter of corrective justice, perhaps it's arguable that your rights not to be punched in the future would outweigh John's right to get compensation from me. So it's not so starkly, a utilitarian as opposed to the ontological duty to compensate, but that the rights of future potential victims to be protected is as important as a matter of corrective justice as the ex post right to get compensation if I did violate the right for bodily integrity.
How much time do I have?
How much time?
About
30 minutes.
About 20 minutes or 15 minutes.
No, 30
No,
minutes.
no, no.
The whole is 30
It means
minutes.
how much do I have left?
I have left cases.
About 10 minutes.
Okay.
No.
Okay, I don't need all the 10 minutes.
About 10 minutes. 10 minutes.
Yeah.
About 10 minutes.
Okay. So the last point that I would like to make, a group of points, is some comments about Jules' treatment of products liability. So the first point is that I think that his approach is over-inclusive because he suggests product liability is governed by contractual norms, or should be governed by contractual norms of hypothetical consent rather than by corrective justice, fault-based tort principles. suggestion to reduce non-pecuniary damages in cases of product liability interesting and problematic. First of all, it involves many distributive effects that were not discussed at all. In the tort reform in the U.S., there are claims against it that it's problematic because it disproportionately hurts women and people that they cannot recover significant amounts of pecuniary losses. But more broadly, there are issues of regressive cross subsidy. I'm not even sure that I have a clear view on that. I think that there was much more to say if you want to defend the reduction of non-pecuniary damages, especially in this specific area as opposed to the rest of tort law. And then Jules seemed to offer a very innovative suggestion of in the line of double liability, so that the manufacturer will need to pay an amount for non-pecuniary damages, but the victim wouldn't receive it. So my main problem is that, especially since we have a pre-existing contractual pricing, this is not a good idea. Definitely not something that a rational consumer would agree.
Or it's independent but not a matter of justice. Because why, after all, would it be the case that there would be reasons, moral reasons, to establish a practice that reinforces and secures distributions that are by any standard unjust? Now, one reason you might have is that that's a puzzle, right? But you can answer it. You can answer it. One way of saying it is, well, you might think that there are permissible and impermissible ways to respond to distributive injustices. And the impermissible way of doing it is by imposing losses personally that you refuse to annul. By saying, well, we're just making the world a more just way if we do this. So the reason I'm taking from you is not because I want for myself, I do want for myself, but I also am making the world a more just place because you have too much and I have too little. And we might think, well, okay, the unjust distribution, why would we think I should give it back? Well, one reason we might think that I should give it back is just the idea that even though we recognize that the pre-existing distribution is unjust, we don't think this is an appropriate way to respond to that problem. We think the appropriate way to respond to this is institutionally, not by having individuals take this decision into their own hands. And so that would be a reason for demanding repair, but it wouldn't make the reason for demanding repair a matter of corrective justice. It wouldn't be that the other person was entitled to it. It's just that there'd be good institutional reasons not to let you behave in this way to do that. And we would give this person a very thin, legal, but not specifically moral ground for making a claim against you. Or we might have a moral claim, but the moral claim would be completely derivative from institutional factors, not from the fact that you've wronged this person in any way, because you haven't wronged this person, you've just done something institutionally that's unacceptable, undesirable, and we don't want to respond to it this way. Okay, now that would be one kind of answer. But that's not the one that's going to satisfy. The one that's going to satisfy is the one that says it's something you actually owe the person, quite apart from that. So that raises the question, why in the world would anybody have a moral reason to, other than the institutional sort I just explained, to help sustain and protect a distribution of resources that is less than fully just? And I have an actual explicit answer to that. And it's an excellent answer. But it's in the form of a formula, not in the first instance, it's not in the form of a substantive claim. It's in the form of an answer, namely that there must be some set, for there to be a legitimate practice of corrective justice, there must be, that is, a distribution of resources must meet some set of conditions for a practice of corrective justice to be a matter of morality. And now I say, what are those conditions? And the condition is that that distribution of resources has to be such that their protection of them satisfies certain kinds of important values that makes them worthy of being protected by a practice of corrective justice, even though that distribution would not be thereby protected by all other forms of redistribution. It's just that as against this form of redistribution, it would be protected. And then I actually offer an outline. You make it seem like I didn't say anything about this. I actually offer an outline of a substantive set of considerations which would fill out that formula, having to do with the ways in which the resources contribute to an individual's freedom, autonomy, their ability for the lives that they live to be things of their own doing rather than things that happen to them. Things having to do with the view that gets spelled out in a lot more detail in the practice of principle, having to do with taking responsibility for how one's life goes, where one's life is something that one does largely rather than something that happens to one, and that resources which are essential to that are the resources which call for and deserve this form of protection by a practice of corrective justice. That, for me, is the fundamental connection between corrective and distributive justice. Of course, that involves thinking about distributive justice in a certain kind of way that people don't have to accept, but it's just, it's a view. Okay, now, that doesn't mean I don't think that distributive considerations don't enter into tort law. I think that in addition to this baseline way, that is among the ground for the justification of corrective justice. I also think that distributive justice considerations can bear in determining what kind of conduct is wrongful. That is, and what is wrong to a person. It's just that I believe a lot of kinds of factors can determine as to what kinds of wrongs are wrong, including things like efficiency. So, for example, who's in a better position to take precautions is a relevant factor for figuring out what the relevant rights and duties are between people. I just don't think, so I think that the people who do law and economics put the precaution test at two levels, both of which are the wrong level rather than the right levels. I mean, they think the liability question is the question about who's in a better position to take precautions, whereas I think that the efficiency issues are in two other places. One is with respect to what the underlying rights and duties we have towards one another, where also considerations of distributive justice there. Now, I don't know if I would hold a particular view of the fact that I owe less to someone or owe more to someone because they're poorer than I am. That would be a particular substantive view that I may or may not agree with. But there are considerations of distributive justice that figure in what the nature of the duties we have to one another is, I nowhere doubt. Just like our ability to take certain precautions are among the kinds of considerations that figure in. Now, my other view is about when it comes to economic analysis, the right thing for an economic analysis person to always have done, just like sophisticated utilitarians, which law and economics people are in general not. The sophisticated utilitarian would say something like this: we do have clearly a practice that's a practice of corrective justice in tort law, right? Let's not pretend it's just a practice of efficient allocation of risk. The burden is to explain why there is and what would justify the existence of a practice that had these features. And there the argument might well be utilitarian, right? But it isn't to say that the features of the system aren't corrective justice features. It's to say that, interestingly, there's a good kind of argument on utilitarian grounds for having non-utilitarian kinds of institutions like this one. But instead, they have the exact opposite view. They deny that they're corrective justice characteristics as institution and say that they're really just utilitarian considerations, right? So I think that all these considerations can enter at two different levels. They can enter at the level of explicating the nature of the wrongs on which corrective justice operates, why losses matter when they do or don't. I haven't spoken enough about that yet today, about why I'm still fixated on losses versus gains and things like that. I haven't said anything useful about that yet. I may not have anything useful to say. That would be one reason why. But and distributive considerations can also apply at the same level that economic ones are. Why would we have an institution of corrective justice that has the features that it does in private actions? And the answer might be, well, let's take a look at the right kind of theory of distributive justice, which may have something to do with the deep structure, which may have something to do with self-respect, which may have something to do with being able to pursue your projects, plans, and goals. And you might have a distributive justice theory about why you have a corrective justice institution, just like you might have an efficiency theory of why you have it. But that won't stop you from thinking that what you have is a corrective justice institution. Right. That's all I've ever tried to argue for. Okay, sorry. We must have been the lunch.
Well, now we apologize to our online audience because we lost the signal for a few minutes due to some.
Oh, really? Did you lose it during the?
Absolutely. I got a complaint from my wife. She said she finally managed to get on, and then she was deprived of her signal.
Yes,
And you deprived of signal, and my most.
Yes, she said you were particularly beautiful at that moment.
Oh, she did?
No.
No.
So we'll hear the
We were
reply.
wrong at that time, so.
Right.
We got John, then we got Diego. Anyone else? All right. If anyone online has a question, Jordi here will take notes.
So I wanted to pursue with both of you the interesting question about the forms of liability that don't appear to require wrongdoing, but that otherwise might be thought of as corrective, if that weren't a criterion of being corrective on the Coleman view.
Right.
So I want to think about some of these, and I want to know really what Jules might say, first of all, about the common law action for debt. Right? So it's a very interesting case. So on any view, the debt must have fallen due and has been unpaid, but the debt might have fallen due for the action in debt to life. So at that date, there's now a wrong, breach of duty.
Right.
And one analysis is that this is a corrective justice action in your terms,
Right.
because the wrong is the ground of the liability. It's the non-payment of debt that constitutes the ground, not the existence of the debt to begin with, right? So there's a corrective justice theory of debt, and if it were a good theory of debt, it would be easily extensible into lots of other areas of restitutionary liability, money hadn't received type actions, where much the same structure applies. It's true that you didn't do any wrong by seizing the asset,
In the first place.
but on the day when you didn't pay for the asset that you seized, because you had to pay in order to make the seizure permissible, you did commit a wrong, which is the composite wrong of taking the asset and not paying for it.
Right.
And that would now be still corrective justice, but corrective justice as it were in the litigation remedy, not in the original structure of your transaction, because it was at that point you had committed no wrong.
Right.
So that's one analysis. Now another analysis of debt.
I believe that.
And so another analysis of debt goes a bit differently though, and it might be more conducive, I wonder, to somebody who holds your views about the restitution rule in types of cases. You might say, well look, it's not exactly as Gardner said there. It's more like this, that the ground of the liability is just the transaction by which you undertook to pay. And it's true that as a condition, a mere condition of getting access to the courts, you have to show that payment fell due. But that's not the ground of the liability. That's just a necessary condition for getting your remedy in court. Otherwise you're wasting the court's time. You haven't waited long enough. Right? It's just a bare condition rather than a ground. And you could also make that analysis of some of the restitution cases. No, it's not that the non-payment of the transfer cost in these restitutionary cases is a ground of liability. It's just that it's a condition to make sure that the action is right, as it would be described in an administrative law.
Right.
And that's a totally different picture. And the reason why I'm asking you to sort of choose is because I want to know a little bit more about what the difference is between a ground and a condition. I think this is really crucial to understanding what the grounding relationship is supposed to be in a corrective justice scenario.
Right.
So that we can sort the cases of the first type from the case of the second. And your analysis of debt would be a useful way to hammer that out, I think. That's the payload.
What's your take?
Well, I'm not totally sure. I don't feel that my...
I don't feel a pull.
I don't feel a pull either way. I think it's very interesting to reflect from here on what a ground is. I've always found it very hard. I know there are grounding relationships.
Right.
And they're not just relationships of conditionality.
Right.
Right?
Right. So that would just be, you could substitute for the ground condition a more general term of in virtue of.
Yeah.
So
So
in virtue of this, but doesn't tell you.
That doesn't do it.
Doesn't tell you
what
what
makes the non-expiry of the or we won't be able to do the sorting.
Right. So the question is, okay, so so let's take a strict products liability case where we don't, not products liability, let's just take a strict liability case in which we don't think that there's a wrong.
Right, originally.
Yeah. Right. Like a blasting case.
Yeah. Let's just say for the sake of argument, there's no wrong originally.
There's no wrong. That is, the wrong would be to blast negligently, or to blast without adequate protections and so on. But you do all that, and you blast as safely as anybody can humanly blast. And then people are injured as a result. Now the thought is, what is it when we say that you nevertheless owe people liability, or that you have to compensate them, that you're liable for their losses? What is it that we're saying is the ground of that, as opposed to the impact of that? Right? Because I'm saying I don't put it in terms of the ground. I actually put it in terms of the impact, as the paying of liability here is what is a necessary condition for the conduct that you engaged in being permissible.
Right.
Right. So that here, if you had paid the people ex ante versus ex post, that would have been just as good.
Right. But now you haven't paid. Right. Now you haven't paid. Today has come, and they want to sue you. And they say, you haven't paid, time is up.
Right.
Yeah.
Well, I'm inclined to think that what you did was a wrong to them. The wrong being you injured them without paying. But of course, you don't really pay until you're in court. So it's not like, it's an awkward thing, because if you were supposed to pay some time before they were injured, then it'd be easy to say you didn't do that. And so therefore, when you blasted, you actually committed a wrong. And here we're saying, well, no. Your blasting itself, we decided we weren't sure whether it was a wrong or not a wrong. Unless you pay compensation. And now, there's a date due for compensation.
Like a debt.
What?
Just like
a
a regular debt.
And that's a debt you owe them.
Yeah.
As a condition of your being permitted to do this to them.
Yeah.
You didn't do that. You didn't pay your debt. And so now that you have to pay them, what's the ground of that? Well, is the ground of that what you did was wrong, in which case you have to pay them, but of course that's not true. You always have to pay them. You have to pay them whether it was wrong or not. Right? It's just that you're in court for the fact that you didn't pay them. So the ground isn't that you did a wrong.
Or is it?
So it's a category 3 for you?
I don't know. That's what we're trying to figure out.
We're trying to figure it out. It's clearly a test case for the category distinctions.
Yeah.
So I'm trying to think there's a thin sense in which all these actions are probably corrective justice ones. That's to say that they only become ripe at the time when duty's been breached, right? So they should all be thought of on the model, eventually, of reparation for wrongdoing. Right? Some of it quantified by ex-ante agreements about debt and so on.
There are compensation for wrongdoing, wrongs.
Yeah. But tort then, or classic tort, core tort, the core bit of tort you're interested in, turns out to be doubly corrective in some way, or deeper, more corrective.
Wrong, and then
there's a prior moment at which it's wrong, even before the
issue of whether you
paid or not.
So it seems that there's some sort of subtle difference there in structure between the grounds.
Maybe I'm missing something, but I think, as I said, if you pay before the trial, then there's no need for a trial, because the purpose of the trial is already satisfied, and that's all.
So
There
this
is
is
a wrong.
wrong.
There is a wrong. There is violation of the victim's right not to be harmed in certain ways.
Right.
In that case, by hazardous activities, that's my indemnity right. I have this right. So by harming me, it's a way of violating my right, my indemnity right. And from there, if the injurer pays voluntarily, then there's no point for any trial.
But that's
Well, point is a misleading phrase too, ambiguous, between whether there's nothing useful or valuable to be served versus whether there's a normative ground that is just being put aside because it's serves no purpose beyond the norm.
But what would be the purpose of the trial?
Well, there might be a vindicatory purpose to establish that the money was paid not ex gratia, but under the heading of a liability. Some people want to do that.
Yes, you might want to do that because you want the record, for example, of this party who engaged in blasting to know that they actually had not complied with the conditions of.
But maybe those are different purposes that protect
But in fact,
victims' well-being and making the other person responsible, because he took responsibility and my well-being is protected at the same time when he pays voluntarily. So maybe other considerations just go to other demands of morality in general.
But there's something
we can find another.
Diego, there's something revealing about the fact that for minors it's compulsory. For young people who aren't able to end a trial by themselves, even if a settlement is reached, the court has to approve. So this is because the liability issue remains live, and the court has to settle something about liability in spite of the
Maybe
fact.
not. Maybe it's just protection of the interest of the minor.
Yeah, but protection under the heading of tort liability, not protection just per se. You could protect the minor by sending them to social services, but this is protection of their interest in tort law, which is a special
And
interest.
because those are the experts that can certify that the interest of the minor is not being violated.
Right.
So
Well, they're interested who can
they know.
they can certify. They certify that this interest, namely
Has
the
to be
interest in corrective
certified.
justice.
This
has
is
to-
not
it has to be
situated,
that
so
one, rather
that
than
might be a
this one.
justification, but this is an additional, it's a special case in case of.
But you might say that the other ones are the special case. What I'm saying is the adult ones might be the special case. It might be normal to think that the experts, in this case the court, who understand corrective justice, should decide always what corrective justice does. But there are special exceptions to leave people alone. It's boring to have to go to court when you've already got happy. All this kind of stuff. You know, so that these would be the exceptional cases. So I don't think we should assume that the infant ones are odd and that the adult ones are normal. It might be that.
So here's the way of making your point. Your making point is there's something missing in my statement of the case, of the issue. Because if I say the paying of compensation makes what would otherwise be a wrong permissible, and then I could use, and then it's really a sort of a time slice perspective on this, because if you use as your example, you say, well, it's really just like going to a restaurant and ordering a meal. Well, of course, there, the paying of the bill is something you do at a time, and of course, it would be impermissible to walk out with it. And then if you paid the bill afterwards, no one in their right mind would say that when you paid the bill afterwards, what it was an instance of making permissible what you would otherwise have been impermissible.
Right.
That is, there's only one way of making permissible what would have otherwise been impermissible, and that's paying when it was due. Right? But when you're talking about tort liability, by ex hypothesis, you're not paying when it's due. You're paying after harm has occurred, because if harm hadn't occurred, you wouldn't have to pay. You could have paid in advance people to take on the risk. That would have been okay. That would have been, see, that's an example in which it would make permissible what would otherwise be impermissible by paying in advance by contract. But provided people thought that, wait, let me finish. Provided people thought that those who accepted compensation were good assessors of their own risk. But in the strict liability case or the blasting case, that's not when you're paying. You're paying after an action has been brought, demanding that you pay. And that's kind of an odd thing to say, that you're paying when it's demanded that you pay for an injury that occurred, constitutes a making the action Not a
No,
torts
no, no,
case.
no, no. It's attempting to leave the restaurant without paying once you ate the salad.
No,
That's
no,
wrong.
in English law
No.
is different. In English law is different. The English law
Intending-
position is that when you eat the salad, if you already formed the intention,
Yeah,
that's already theft.
fraud.
That's
Ah,
theft.
maybe, okay.
Yeah, it's just, but these are tangential questions because you're interested in the trespassory character of it, which is not the same as the criminal character. So,
Okay.
yeah. For that reason, it can't be burglary in English law because there's no trespass.
Okay.
But it can be theft because there's an appropriation of the salad. Yeah, it's interesting. We've distracted from Jules's.
No, we're not distracted.
So, are we abolishing your third category, or are we saying that it's?
That has, I mean, strong results if you abolish it, because if you abolish it, you have to say that you're paying. Blasphemy was not a wrongful action, and you're paying just because blasphemy was harmful,
Of course.
which is something I will be delighted you to say.
Oh yeah, no, but I've always
So-
said that. I never said it's wrong.
Different reasons.
But well, you said you correct the wrong by paying.
No, you don't correct the wrong. You take conduct, you change the normative character of what you did, which is different from correcting the wrong. Because what my view is, in the other cases, you haven't changed the normative character of what you've done. The fact that it had the character it had is what explains why you're paying. But here, it doesn't explain why you're paying. What explains why you're paying is you're affecting the normative character.
But that can be right, because yesterday
What do you mean it can't be right? It could be right.
when we
It
read,
may not be.
and it's not right. No, yesterday in the restaurant, we're all doing something wrong because we were eating the food that we didn't pay for, and we just
you
correct
want
the wrong when we leave. That's
That's
crazy.
crazy. That's crazy.
That's crazy.
That can be.
That's-
Right.
That's not.
I
That's
agree.
not a terrible
So-
position.
That's
I
right.
will never correct what we would be wrong, or in general, you don't correct. You don't see contractual relationships as correcting.
Last case.
The last case is different.
Right.
It's different. It's not.
Well, at least there's a real debate there about whether the Blasting case is different. It seems to me plausible to think that in the Blasting case, even if you paid right away, that wouldn't be quite the same as the paying in the restaurant. And that's something. Is it because there's no custom concerning this, or what? I don't know what the reason is.
I don't know what the reason
But
is.
there's some difference maybe just in the
So
pragmatics.
let me ask you a question then about, because this raises a general question, not necessarily about wrongs and causation, but about how we're supposed to understand a whole range of things, like fees, licensing fees, and,
Mistaken payments?
well, I don't know about mistaken payments, you would have to explain that to me, but licensing fees, prices, all those regulations of a certain kind, all those things, you go hunting, but it's not permissible unless you have a license, and you have to pay for the license. So it's conduct which is wrongful, these conditions, right, but you normally satisfy these conditions ex ante. So the question here is whether the satisfaction ex post really can never, so it's actually, if the argument is that there's something about the ex post character. Of course, in a restaurant, it's after the fact, but it's not ex post. It's temporal, but it's all part of the same transaction.
That's right. That seems to be the key.
Yeah, it's the difference between it being later and being ex post.
Yeah.
Right? It's all part of the same transaction. The transaction takes place over time. The payment comes later.
Yeah.
Right. But it isn't that the payment changes the normal
That was the point I
character.
was originally trying to make about debts. Exactly.
Right.
Yeah.
Right. So if that were true, if it's a mistake to analogize this, then the whole economic analysis of this, forgetting my one category being problematic, the whole economic analysis of this would have to be abandoned, because it would never be the case that what a liability rule does is identify the price you're paying for legitimately taking someone's conduct, taking someone's property, the absence of which would be a wrong. It's because, of course, the liability that you're paying is after the fact, once you've taken the property, which is a wrong, right? And in all such cases where you say,
Well, with the exception of cases where you're disputing the amount of the bill in the restaurant, all right? So
Yeah.
there's a special class of cases where it's conceded that there's a price, and the dispute is just about
what that price is, yeah.
But
what is a wrong or not. Or you need philosophical work in order to have a good doctrinal apparatus. And that's interesting because if we can get this right, we cannot get it completely clear. There's something to think about.
Right.
I have a question regarding another point. I think I agree with Tsachi, and I have written this too, independently.
So
I
then
have
you're
read
going
before,
wrong.
but sorry, I'm probably wrong. I have to correct it, yes. But so far my doubts are regarding the idea of sometimes we protect certain legitimate interests with rights.
Yeah, by rights, yeah.
By rights. But the idea is that according to your own conception of rights, rights are just a set of valid claims. Sometimes one valid claim.
A set of what?
Valid claims.
Valid.
Valid claims. Yes? So if you have this conception of rights, even when you protect legitimate rights from wrongful conduct, you are protecting those rights, those interests. Sorry, even when you protect legitimate interest, saying that if there is a legitimate interest and another right what is at stake, then the action of the defendant must be wrongful. In a sense, you are given compensation, so that's a right in every case.
I don't know.
Conceptually, if you agree that.
No, so that has to be wrong.
But you got the point.
No. I mean, of course, I understood the point, but I didn't get it. Which is, if whenever you're giving compensation and there's a ground for it, and you say that there's a right to compensation, then there had to be a right that underlined it, so that the distinction between legitimate interest that sometimes can give rise to rights to compensation and rights giving rise to rights to compensation is empty. That's the point that you're making, right? But that can't be right. I mean, because we can give people rights to compensation when there are no underlying wrongs or breaches of duty or anything. We can give people rights to compensation for utilitarian reasons, for social justice reasons. We can give people rights to compensation for sorts of reasons, so that it doesn't entail that there's a right involved just because the ground, whatever the ground is, gives rise to a right to compensation. So I can give you a right to compensation to shut you up, right? That is, so because I can give you a right to be compensated in order, under certain sets of conditions, in order to make you happy, right? I can give you a right to compensation, just like I can give you a right to demand a higher salary 3 years from now, not because you had a right which was violated or anything.
I think that once you give me a right to compensation,
Yeah.
or the,
A right to have whatever losses you suffered.
for example, you're protecting certain legitimate interests of mine. Certain.
And the way I protect these interests is to give you a right to compensation.
No, the thing is that once you give me a valid claim, get compensation, you gave me a right. By
A
your
right to
definition.
Yeah, I
by
gave
your
you a right to
definition-
compensation.
Yeah, and we can understand.
But that may be the only right you have.
That the right to be compensated is different from having a right,
Why?
because you may have an injunction to prevent someone else from violating it.
But
So
they're
in
not.
the case of compensation, you only have the right to be compensated.
They're not fixes contents of rights.
But you
We can
can
speak
base
of.
it.
No, you can say several things. You can say that I have a right not to be injured because if
that,
and you have a right to be compensated, but
so that was the whole exam. That's the whole point of the Judy Thompson thing. It's not like it might be the case that you have no right to do anything about what this person is going to do to you. None. No rights whatsoever, but you have a right to compensation. You might not even have a right to self-defense to protect your interests. But we do recognize that you have legitimate interests here, which were adversely affected by allowing the permissible person, the bystander, to redirect the train towards you.
Wouldn't make sense if you say, do I have a property right?
Now I have to think you have a right to shoot the guy.
No, maybe I have property right to this
You think
bottle.
you did?
Regarding this bottle, maybe this bottle is mine, and the only thing that means is that if someone takes it from me, I can get compensation. So my property right.
That's
is
all it
defined,
means. That's the
that
content
means
of your right.
compensation. So it doesn't make any sense, in my view, to say that the only thing you have is a compensation right, because that's just names, labels. Claims to compensation can be enough to meaningful talking about rights in general, property rights or whatever. That's my point. That it's not undisputable that you can make this distinction between protecting legitimate interest and that was my point.
It's fine with me.
No, then you have to admit that there's always wrong, but you won't have wrong about that. Maybe Tsachi. I don't know.
I just don't know what hangs on it. I mean,
No, nothing harmful, just clarity, conceptual clarity. I think you can embrace this.
No, I just don't know. I'm not sure anything is added is the thing, because it would turn out to be the case that in the cases in which you have legitimate interests that are protected, but they're protected by the right to compensation, and then the legitimate interests that are protected by what I'm calling by rights, which the thought would be, okay, let's say they're both protected by rights.
Yeah, you're saying the same
And
twice.
one is just the rights to compensation, the other is a full panoply of rights of actions and powers and privileges and so on, and the other one just is the right. Well then, there's the only wrong would be, and this is the important thing, the not compensating. Because that would be the only thing that would constitute a violation of that right. And that it would not be true of the other cases. So you wouldn't say, so even if you invoke rights in both cases, you wouldn't thereby be invoking wrongs in both cases. Because the wrong in the rights case, the full rights case, would be all those other things that you couldn't do. But the only wrong that would be in your rights case is the not compensating. So
this shows the perils of using the language of rights, because the individuation of rights is very hard.
Right.
Sometimes we think of rights in gross, as I say, as significantly shaped by shaping a number of duties.
Right.
In other cases, we want to slice those up, so that's a whole different bunch of rights.
Right.
And it doesn't help very much that way. So rights talk doesn't really help. If you individuate the duties, as you're always usually tempted to do, then you get the clarity you need.
Yeah.
I think.
Yeah. I'm a rights inflation fighter, but I do think there's problems with the thought that morality can be articulated entirely in terms of duties. I do think, that there are these fundamental, let's call them meta-ethical questions about how we divide up the normative landscape to its fundamental, if not its atomistic parts. And so many people are concerned about rights as the
atom.
one of the atoms is individuation problems. But it's interesting that some of those people who resist rights in this way, who I think is John and Raz. I think Raz thinks of rights in a way of, it's kind of instrument for thinking about how duties come together in certain kinds of ways. But that rights are not but focus instead on reasons. Many of the people who are puzzled about reasons are puzzled about reasons for the same reasons that the reasons people are puzzled about rights, namely individuation of reasons. Right. But I think you're going to buy some poison no matter where you go, right? You can't start with just duties, that's not going to, because there are a lot of duties that you have that, you know, you can't have morality of only duties, because there are a lot of things that are morally inapt or inappropriate to do that cannot be explained in terms of duties. And the, you know, the rights duties line, see, I'm kind of drawn to the reasons, but not for reasons that I understand. I find the people who are lawyerly and move into moral philosophy tend to think about the moral landscape juridically. And the juridical categories are rights, duties, and so on. And they tend to think about those as the fundamental features, right? There are other people who have never spent a moment with juridical concepts, and they think of ought, and you know, they have a whole range of terms, and right and duty are, they say, in very special circumstances. And then there are the people, you know, who are practical reason people, and they think, right, they tend to think that when you're talking about action, you're talking about a set of considerations that bear on it. We should think about considerations in a certain kind of systematic way, and they are reasons, and they operate in relationship to one another in certain kinds of ways and so on. And so that, you know, they have a structure of reason and practical reasoning. You know, so it's, you know, it's not the case that never shall these meet. They do all the time. The problem is sometimes people find dissatisfaction with one another, and it really has to do with how they break up the atoms. You know, you know, I grew up under Feinberg, and Feinberg was a rights guy, right? Really, right? Feinberg was a rights guy, and but I myself, I just don't know about rights. I know about wrongs.
Yeah, you were wrong guy.
I'm a wrong guy. I'm a wrong guy. I'm a wrong guy and a lost guy. I'm a wrong guy, a lost guy, a misfortune guy, a bad luck guy. I'm not a particularly uplifting guy. In fact, for someone with these normative categories is so central in his academic life, I'm pretty happy.
Anybody else? People? No? Well, Carlos.
It's just to ask for reactions. I think that you both avoided the way in which we could explain when consideration of distributive justice enter into torts practice, right? We all know that they do enter, and I think Jules has a strong point that, you know, it seems that it also works distributive justice works as a context where the practice of corrective justice makes sense, right? But I think it seems to me that it's more plausible. It's plausible to think that consideration of distributive justice enter into the picture when we think that personal responsibility is less important. And I
Say it again, when you think of the
when we think that the personal responsibility is less
Yes.
important. And you know, Jules, I don't know where, but at some point he says, well, the paradigmatic tort is intentional tort. Now, and I think we all will agree that if the tort is intentional, distributive consideration shouldn't enter into the picture, right?
I'm not sure I agree with that, although I probably would say that they would work in different ways. But I can try and give you an example from my more recent work. So one of the things that I'm arguing.
Let me just finish.
Okay,
So
sorry.
the idea is,
Go ahead.
if this is possible, then distributive considerations are more, are more amicable, or we think that we could resort to distributive considerations when we're willing to see sort of the practice as a collective one, and a practice that tries to achieve collective aims and values. And sometimes when we feel that's not the proper case,
So they can figure in torts, but how they're masked becomes incredibly important. So, for example, not allowing insurance companies to differentiate actuarially as well as they might fine-tunely is a way of taking distributed considerations into account, not with regard to the duty you owe or the standard of negligence or anything like that, but in terms of, living in a bad neighborhood that's filled, say, with, so if you talk about ghetto neighborhoods that have higher crime, higher theft, more accidents, so on and so forth, and if an insurance company were allowed actuarially to really draw fine distinctions, it would be much more expensive to buy insurance. It already is expensive, more expensive, but it would be much, much, much more expensive. And that's kind of prohibited for a variety of ways. So that's a way in which distributive considerations figure in a way that people think is permissible, in a way in which it wouldn't be permissible. And I think all those factors should tell us something about tort law. I really do. Both the fact that they're there and where they need to be put in order for us to be comfortable with their being there. I'm kind of a believer, this will be my main point, I'm kind of a believer that there are these deep moral aspects of tort law, but they're much thinner than we sometimes think they are. So all this talk about distributive justice and corrective justice and so on really makes them sound much more weighty than the practice really is morally. I think the practice morally is much thinner. And that I've spent my career overstating how thick it is.